Hello everyone. It's a pleasure being here. My name is Fernanda, Galera, and without more further delay, let's start. So basically, I'm a dual qualified solicitor, Brazil and UK, and today I'm here to basically moderate this fantastic panel with Professor Juliano, Mariana Valente, that will be online, and Saskia. Our idea today is to discuss not only copyright and generative AI, what is kind of basic, but to go a bit further in this topic, mostly discussing how the model training based on large volume of digital data can or cannot be classified as copyrighted works. Everyone has been discussing mostly if you could copyright an output, but our idea is to discuss a bit more the training of it. There is recent discussions highlights issues between the distinctions what is digital data and authorial expression, the nature of computational processing, not intended only for human author computation, and mostly the impacts on creative markets and the legislative proposals, mostly across different jurisdictions, Brazil, European Union, and even United States. So this panel will bring different experts with distinct backgrounds, mostly focused on new technologies and copyright, which will bring their studies to reflect how current copyright system is adapting to the technological advancement, discussing mostly these different approaches. Firstly, we'll speak Dr. Juliano Souza, Albuquerque, Maranhão, Associate Professor at the Faculty of Law of the University of São Paulo. Postdoctoral researcher in... That's okay?
Yeah.
Well, he's a huge expert in Brazil, mostly focused on AI with cross experience over Europe, and he will present his new study provided by Legal Wings, focusing on the critical analysis of the solution provided by new Brazilian bill on AI, discussing, again, Gen AI and copyright. Followed by him, we'll speak Mariana Valente, who is Assistant Professor of International Economic Law at the University of St. Gallen, Switzerland, and Associate Director and Founder of the Internet Lab in Brazil. She's also a well-known Brazilian expert with focus in AI and platform governance, copyright, and access to knowledge in the digital environment. Our last speaker will be Dr. Saskia Ostendorff. I'm sorry if I mispronounced your name.
No, it was perfect.
She is the General Counsel at Wikimedia, lawyer and policy expert in media, copyright, and digital regulation. Her work focuses in particular on freedom of expression, platform regulation, generative AI, and the governance of emerging technologies. She's also co-editor of a leading German textbook on copyright law and publishes regularly in academic journals. Okay, well, you probably have seen all their mini bios in our website. Plus, she will discuss about how Wikidata is dealing with copyright and big data in our new projects. Mostly, this panel intends to discuss and respond four very specific questions. So, first would be, should the training of generative AI models with data extracted from copyright works be considered equivalent to the use of copyrighted works themselves under the copyright law, or under what circumstance? Second, is the copyright or authorship law adequate to guarantee compensation for creators in the age of AI? Third, how have different jurisdictions such as EU, US, Brazil, maybe UK, approached this issue in their legislative and judicial debates? What regulatory and governance alternative can balance innovation, creators' rights, and legal certainty? To conclude, it's time for the Q&A, and I will open to your question mostly. Of course, I have my own. I have already prepared as I read some study. The focus would be to check out what you guys would like to say. Without further delay, please, Professor Juliano.
Okay, thank you very much. It's a real pleasure to be here in company of you in this panel. So I'll talk a little bit about AI training in copyright. There is this recent study by Lawgorithm and Legal Wings Institute. Unfortunately, it is only in Portuguese, but very soon we are going to publish the English version. So the specific question that is faced by this study is the unauthorized use of protected work for AI training a violation of copyright? Is a specific question about input. Here in Europe, you could answer that very quickly by saying, well, there is a TDM exception. We don't have that in Brazil, so the perspective I'm going to defend here is a deeper one, to the effect that AI training does not involve reproduction of a protected work. And this is a very important aspect of the Brazilian debate, because in the Brazilian draft bill for AI, it is proposed a rule which imposes AI developers to first identify all protected works in their databases. Second, manage consent, opt-in, opt-out. And third, pay the authors in terms of copyright indemnizations. And this puts a very huge burden on developers in Brazil, and this is the hottest topic. We are finalizing the process of, we're concluding the legislation in Brazil, but this is the main difficulty for its approval, because of course developers are saying this will kill AI development in Brazil. On the other hand, authors are concerned about their remuneration. And I would like to make quite clear that this is a separate question regarding if it's fair or if there is any moral duty or even legal duty to remunerate authors for the use of their work for AI training. You may have other justifications, moral, legal even, to pay authors in other forms, as I was discussing with Saskia, maybe contributions for associations of collective works, authors, and etc. But the specific question that is very critical is whether we are dealing with reproduction of a protected work when we are specifically in the procedure or in the process of AI training. This is also a different question regarding if we can use the GenAI system to violate copyright, because this is a question regarding the output. Once a system is made based on a foundational model, is it possible to specify in the prompts or in the requisitions for the output something that comes quite similar to the protected work? Yes, it's possible, I would answer. And can it constitute a copyright violation? Yes, it can. Regarding the second one, is it fair to remunerate? Yes, I believe it's fair, but not in terms of a copyright indemnization. Can fine-tuning of AI foundational models violate copyright? Yes, it can. It may be a training regarding a specific author or style. That can be, in some hypotheses, be something close to the reproduction of copyrighted work. But let us focus on the first question. Is it a reproduction of work? If we go for the moral justifications of copyright that are in the basis of every copyright legislation that are coming from the Berne Convention and etc., we have, for instance, the Lockean theory, where the author has a moral right to appropriate a portion of their own labor. The utilitarian theory would say that copyright is a social mechanism to incentivize an individual author to produce. And the personality theory, which is more congenial to the continental copyright tradition, which is based on Kant and Hegel, says work is an expression of author's personality as a means for human flourishing in society. So in these three most basic conceptions of the moral justification of copyright, you have an individual component. So according to Locke, it's the individual created effort or sweat for utilitarian theory is the incentives for the individual author to produce. So there is the individual component. And the author's personality is something quite specific to a particular individual. So it's an instance, it's always an instance of an individual effort, disposition, or personality. There is also the social component. You can capture appropriate the value of the work because you added value to society. It's a social mechanism to incentivize individual production. And also the acknowledgement of the author personality is something that comes from the acknowledge of the society of this personal identity through the work, particularly in Hegel's theory that comes this concept of Anerkennung, the acknowledgement by society of an individual. So all that have also this societal component that has to do with the work being expressed by some mean to the public, to society. So there must be a media and also meaning conveyed by the author through its work, through his work to the public. So what are the essential elements when we talk about a work and then a reproduction of a work? Individuality, each creator has a distinctive way of expressing an idea. This individual expression is materialized, and there is a potential relationship between the author and public of communication. And for communication, meaning is presupposed. So, whenever we talk about reproduction or any procedure that intends to be a reproduction of a work, there must be first this individual expression of a particular author, and second, the procedure or some steps that are going to result in the communication of this work in its meaning that is perceptible and apprehensible by the public. So, if I make a work of art available on the internet, if I print copies, but there is, I would call this all expressive uses because it's intended to communicate the meaning of this particular work produced by an author to the public. But there are also non-expressive uses where nobody would talk about copyright. For instance, file compression, backup copying, indexing for search, and I'm going to defend that training generative AI is of the same sort because it doesn't involve any attempt or procedure or phase for reproducing a particular individual work to the public in its own meaning. So, to understand that there is this distinction which is important to make between digital data and analog data, which are, in this study, I'm not going to go through every detail, but we made an effort with computer scientists from the Institute to detail why there is no meaning conveyed when you are training AI systems, and also why no individuality is preserved in the resulting AI model that represents the aggregate of works. So basically, first, there's a distinction between the data, the analog data that can be captured by humans, and digital data, which is embedded from the original work. So there are many procedures for embedding texts, audio, image, and video, where all this, the analog work is going to be codified. And once codified, once you have the encoding, the conversion for the binary codes, then you have the syntactic manipulation, and then there is an intermediate phase of decoding, where I convert back to signs, and then human can perceive them by some equipments that are associated to the computer. So only stage 1 and 5, the input and the output, are humanly perceptible. All the second to the fourth phase, they are only syntactic manipulation of numbers that cannot be apprehended. And all the training is the training of AI systems. It uses digital data that correspond to analog data of particular works. But within this procedure, everything is syntactic, and it's intended to extract general patterns and nothing individually specific to any of the works that are part of the procedure, that are part of the databases, are retained. So we explain how this happens in statistical models that don't capture particularly only concepts and predictions about concepts with weights. Then we go to convolutional neural networks and emphasize the complexity in many layers, where some features are associated with values or weights. And so all that you retain are features, abstract features, and weights. And so in the end, the output generation is a new combination of those relations between that were extracted and captured from numbers, from these binary numbers that cannot be apprehended by humans. And then you generate something new. And there is some randomness in this new generation in all the models of a Gen AI. So a note only on, and that's why we believe, so since there is no individual aspect of any of the works in the database is preserved by the system, because you extract standards and concepts out of it, then you don't have the individual component of a protected work. And you also don't have the public component, because in these syntactic transformations or manipulations, you do not communicate anything, any meaning of each of these works which are in the database to the public, and it's not intended to. At least when we talk about training the AI foundational model. Since there is no societal component and individual component, within this process, you don't have a reproduction of any of these particular works. And there is an example for a note on memorization or regurgitation that is being discussed in very interesting cases in Europe. One in the Tribunal of Copyright in England, and also a recent case in German courts. They reached the opposite conclusions. And the main question is, if you make specific requisitions or prompts referring to some work, you can reproduce, you can obtain as output something very similar to some original works. But what I defend, that this is a phenomenon, is a statistical phenomenon that comes from large databases, from large variables or points that you can combine in an input. We make an explanation, a technical explanation why this may happen, but in order to defend that this is not a memorization. Although it's said memorization, so-called memorization under brackets, because actually it's a statistical simulation. If you can make this prompt specifying this work, you can obtain it. But first, this is an aspect of the inference phase, not the input and training phase. You can produce these results. So the first aspect is this is the inference phase, is not what we're talking about. And the second aspect, this is a statistical phenomenon. And it's quite illustrative of that. I don't know if you follow that trend at Instagram, where you should put an image of someone famous, and then you ask the GPT to reproduce this image 101 times, but to reproduce exactly the same image. And in the process, you can see that actually the system, the foundational system that is there, is extracted only abstract concepts. And if you put the image in the input, it's not going to be successful to reproduce it exactly. In every stage is a statistical approximation what will be exactly that image. And in 101 repetitions, you see the final output. It's abstracting concepts like there is a green jacket, there is something like a smile, and in the end, there is this abstract picture because the system is trained to capture this abstract. And even in the inference phase, you are dealing with a statistical production. So there is not something like a statistical copy or reproduction. It's only an inference. If there is something to be protected, it's not against the developer who trained the system, but the one who maliciously has used the system to reproduce a particular work. So that's the idea. These are the key takeaways. I'm going to close it now. I think the idea is quite clear. I would like to discuss them with my colleagues, and also I'm eager to hear their contribution.
Thank you, Professor Juliano. Mariana, are you hearing us?
Yes, can you hear me as well?
Yeah, all good. Anyone is not hearing? Well,
all good.
Okay, all good. Thank you.
Thanks. Thank you. Happy to be here. Sorry that I couldn't be there in person. Thank you for making this happen. Thank you also for your initial presentation, Juliano. I read the report with great interest. This is a subject that has been taking my sleep. Juliana and I were members of this AI commission that drafted an AI bill for Brazil, and we had these discussions at the time. And what's interesting is that the first draft that we made came out right as ChatGPT was booming, right? So we didn't have the chance to discuss generative AI. And it's interesting to read this report because I think it does reflect many of the discussions that we were having at the time about thinking whether analytical uses of works, if they count as a relevant activity for copyright, right? And I think something that's very central to the report that the Legal Wings Institute developed is this idea of expressive uses, right? And considering that the expressive uses are the uses that are relevant for copyright for different reasons, for the different justifications that the report was bringing. And I'll go back to this history in a bit because I want to say why this subject is taking my sleep. Because I do feel there's something different about generative AI, right? And from the beginning, since this boomed, I mean, it's not that it boomed with ChatGPT. Of course, we know that there were many applications or proto-applications, let's say, of generative AI before. But this was when, around 2023, right, 2-3, when these tools really became available at a large scale to users in general, right? And I think this is when it really became a concern because precisely of a possible substitution effect that these tools may have in comparison with artists, right? With the works that artists create. And in my research, I approach copyright from a sociology of law or sociology perspective. So I'm usually looking at it from the perspective of stakeholders, their demands, and how they repeat over time. And I see this that is happening as something that's quite common, right, in copyright history. When we look back, we think of the development of new technologies. There is always this moment when we're looking at the copyright law as it is and trying to understand where things fit into the categories. And I think there's also a moment when we start thinking whether it should be reformed, right? To really be able to, let's say, reestablish a certain balance that one thinks that a society thinks that is important, right? And I'm saying all that because I think a very important question here, and it's a question that is in the report as well, is what is the right balance, right? And I think one of the things that this report is referring to is that if you create a system in which you need authorizations or a collective license to train AI, even before knowing that this is going to be, that this is going to work out, that this is going to be profitable, that this may not be the balance that one wants, right? Especially if you're thinking of developing the AI in a particular country, AI tools in a particular country. On the other hand, there is definitely the issue of creators themselves, right? And I think this discussion is also happening because of a broader concern on the side of creators on whether their livelihoods are going to be affected, or a general fairness concern, whether their work is being used to feed, let's say, markets that we know that are also very highly concentrated, right? So I think the fairness question comes from this. And then I go back to the question of training, right? Because I think that with the technical explanations that are brought by the report, it's pretty convincing that under the current copyright system, if violations are happening, they're not happening on the training level, right? They're happening on other levels. The question that I have when I think of this is then whether we shouldn't be looking at the other levels and how far it's possible to separate all these different layers, right? If the problem is just one. And I think it's helpful because you have to see where technically, right, where the use of works is happening and how, from a copyright conceptual perspective, there is a relevant act and there is a violation, and this is precisely what all the courts are looking at and legislators are now also looking at. But at the same time, from a perspective of thinking of fairness, distribution, and reform, I wonder if we shouldn't be also looking at this more holistically. And this is really a question. This is something that I don't have an answer to. So I'm thinking that it's becoming clear that the harm is not happening at the training stage if one is if one is concerned with the substitution effect, right, that generative AI may have on works. But at the same time, this is a prerequisite, right, for the following stages. How do you bring all these things together? And this takes me to the solutions that are being thought. I'm equally concerned with these solutions that try to just establish, let's say, the institutional copyright system as is to this whole process of training, fine-tuning, prompting, especially because we're really seeing that the instinctive response that's being built, and that's on the one hand licensing, right, and on the other hand building, let's say, walled spaces so that works aren't used for training AI. These are two, let's say, instinctive responses that don't seem to address well the issue of fairness that's being posed, right? So on the one hand, considering, let's say the report mentions the New York Times lawsuit. There's also the case of a large Brazilian newspaper, Folha de São Paulo. What we're seeing is that these large actors are already entering into licensing agreements with those big players in the generative AI field. And the issue that is the livelihood of creators, I don't think is really being addressed, right? On the other hand, I've also been seeing a lot of the instinctive response of, so let's not publish open access anymore, or let's not leave things available. And I won't go too much into that because we have a proper Wikimedia person here to discuss those issues, but I'm very concerned that we also favor a market of licensing between big players and all the benefits that we know that come from commons, that come from the availability of knowledge online, that we also start losing them, right? We're seeing in the side of licensing that's happening not only with newspapers, but for example, in the academic industry, right? So Taylor and Francis signed a $10 million deal with Microsoft without even notifying their authors. HarperCollins offered around $2.5 thousand per title to license their work for AI training, and the Authors Guild considered this far below what would be fair. And this is really the distributive reality, right, of the solutions that are being found right now. So just going back to the problem and the framing, right? I think just to finish the discussion about the problem, I think the issue on creating an environment where AI, generative AI, can flourish in a particular country, and that's an issue that's being discussed in the report, is definitely one of the objectives, right? But there is also the objective of thinking of an economically viable, let's say, market for creators, especially in some areas, right, that are being specifically affected. So what would be interesting solutions for that, right? And we have, I think Juliano mentioned funds, but I'd also like to mention this idea that's been going around of infrastructure reciprocity, right? Like mechanisms where communities can maintain ownership of data sets, set their terms, require compensation without depending on copyright enforcement. This is something that, let's say, Wikimedia Enterprise does, right? Perhaps we're going to talk about this later. But at the same time, models in which we can think of new ways of guardianship of works rather than ownership. And this is all very complex to implement. And this all runs into the question that's also in the report of how do you think of this nationally, right? Because if you create stricter copyright rules, thinking of the whole process, okay, I'm not focusing on the training part only, but thinking of the whole process. If you create specific copyright rules for a specific country, and then let's say Brazil, that was brought here as an example, yes, you risk that the only thing that happens is that works are trained, that AI is trained elsewhere, right? At the same time, if you consider that this is given, that the system, the way it's working, is how it will be, and this is you can't do much to change it, so countries shouldn't do anything. That seems too fatalist and too much accepting, right, of a model that's favoring very fast innovation, but perhaps not always in equilibrium with the different factors that should be weighing in. So I wonder if we also shouldn't be talking about this more holistically and internationally, right? These discussions are happening right now, for example, at WIPO. It's an organ that's been moving very slowly lately, but there are discussions that are happening there on AI training, and not just AI training, but also streaming, like the whole impact of this digital environment on creators lately. And I wonder if this shouldn't be then the directive, because I think the report is very right in noticing that if we start creating rules, stricter rules for a specific country, that's going to have just a very clear effect of training happening elsewhere. I know that I just reached my time, so I'll stop here to see if we can continue this in the discussion.
Thank you, Mariana. It was a pleasure, as always, hearing from you. Saskia, would you like to compliment? Yeah, please.
Yes. Hello, everyone. I'm glad that a few people are still here for this interesting topic of copyright and AI. The presentation is here. So let me start to introduce to you one of the biggest volunteer projects in the world. And probably, maybe all of you have at least once been on that website, Wikipedia. So I'm interested in the audience, like who used Wikipedia? Hands up. Beautiful. And who added? Ooh, that's cool. Nice one. Actually everyone can contribute to this beautiful project. So maybe the people you have just seen raising their hands, get in touch with them and ask them how they did it, and then you can also be one of an editor of Wikipedia. So what is Wikipedia about? Well, as I said, it's one of the biggest volunteer project. It's working collaboratively, and it is. It's free. It's free for everyone, and I think this is one of the best things about it, that actually everyone can access the information on Wikipedia. And you now wonder, okay, hello, we are talking about copyright and AI. Was she talking about Wikipedia, free information? Maybe you already know where I'm heading to. I'm not sure, but let's go further to some facts maybe about Wikipedia. I think it's super crazy if you have a look at like 15 billion page views, right? It's super cool. And imagine 65 million articles in 300 different languages. Also super cool. Imagine what you can do with that. Imagine how you can bring people together. Why am I talking about Wikipedia and AI? Have a guess inside of you. Answer it, and then let's see if we think at the same line here. Wikipedia, it may not surprise you, is of course one of the biggest sources for AI models, for the training, right? Because as I said, it's free available. But even though that it's open, I mean, open doesn't really mean that you can use it just as you like. Of course, yes, but maybe everyone raised their hand, and maybe you're aware of the CC licenses of Wikipedia articles. So, of course, we defend openness, yes, but it doesn't mean that you just can take it without crediting the other ones, right? So let's have a look at answering the questions that we have here on the table. So should the training of generative AI models with data extracted from copyright works, and here's the twisting angle about it. Of course, I'm looking, yes, the Wikipedia article, as I just said, is a CC license, copyrighted work on the one hand, but of course we want to share the knowledge. But now, here comes the turning point, we also want the knowledge to stay free. And I think this is the First time probably that we are looking from same angle as creators do, just with a different goal here. Yeah, on the one hand, we have the creators who want a compensation. Yeah, if their works are being used for AI training, but yet we already talked about that. You really have to differentiate between the different steps, the training itself, and then the output. We have to differentiate here. So let me state this clear. Like, in my opinion, the training itself, of course, for the European Union, you're all aware of the Digital Markets Act, obviously. I'm just saying that. So under Article 3 and on Article 4, we have the TDM exception, right? Is it clear? Yeah. So the TDM exception, of course, in my opinion, applies to the AI training. And we actually had also an interesting case in Germany where they discussed first if it even applies for the AI training. And the second was the, really weird definition about what is a machine readable output, opt-out. So, it was a really interesting case. Maybe one of you know it's Lion case I'm talking about. It was about an open data set where an artwork of an artist was included, and Lion is a non-profit organization only run by researchers. And they got sued by the artist, and there they wanted to, clarify whether the TDM exception applies to the training. And the court came to the conclusion, yes, it does. But be careful with the machine-readable opt-out here. So they really, discuss what is machine-readable and what's not. But I don't want to go there into deeper, except that it brought up the whole topic of when there is an open data set, how can we actually keep this open data set open? And the same question also applies to Wikipedia information you get also for the knowledge. Because as I said, very large business companies train their models on those articles. So I'm a huge fan if this free knowledge in this very large AI models would stay free. And I mean, you probably know, right? You have to pay sometimes for the ChatGPT Plus, for instance. There are also other ones, of course, but you have to pay. And I really would like to lead this into a different direction, that the knowledge stays free and that you don't have to pay something for a specific answer. So coming back to the questions. So as I said, we had the different cases. You also talked about the GEMA case, right? Where we both have the same opinion about its strange decision here. But the question is, of course, where is the line of a copyright infringement? And in my opinion, it's not the training, but rather the output. And I think there we are also on the same side here. Because of course, it depends how you prompt, and what the output is about. And at the end, it's also what you said is statistic, what's being shown to you there. So let me frame that, as I already said, that copyright artists, they argue they want enumeration. I can understand that, absolutely. And for me, we argue, of course, that we want the free knowledge to stay free. And okay, but like how does this happen? Like, why does that not happen? Like, if you've used ChatGPT, for instance, or other ones, you may have noticed that the references are not always shown, for example, right? And this is like a huge problem because you don't know if it's a hallucination, for instance, or where's actually the verified data about the information you get there. I mean, this, I think, is clear to everyone that this is also a huge topic. So in my opinion, the legislator really needs to fix, on the one hand, the compensation topic for the artist, but also on the other hand, and this is actually based on this line court decision I was talking about, also needs to, and that's actually the first time that copyright law could maybe a chance to help open knowledge, open data to stay open, to actually give the companies the duty that if they rely on open data, they are forced to also open up their data sets, open up like what the model is about and everything. And I think this is also really in line with the European AI. Help me, I'm missing the word now. It's late, sorry for that. You know what I mean? That this is everything would be aligned. So what I would really prefer is if the legislator not only looks at the artists, but also on how the open knowledge can stay open and what the legislator can do about. Maybe legislation is not always the solution. I mean, this was always what you already said, that's maybe about fairness. But when you look at how copyright actually started, or what the sense of copyright is, it's about, yes, fairness for artists and for compensation. And as I said, we don't want compensation. We want the free knowledge to stay free. I did some legislation proposals about the open data. I think I also have it on here. If you want to read through this article, it's in German. If you're really good in German, then have a read maybe. I think there's also a summary in English if you're interested. So that's what I would propose. As I said, I would do a legal compensation for the artist, but we also need to fix that if open data sets are being created like Lion did, they shouldn't be sued or liable for infringing copyright, because their researchers, open data set, they provide something, yeah? They provide a lot. They just make this for the public. They give something back. And I really would encourage those researchers, and especially in the AI field, we have a lot, especially in Europe, great projects which actually build those open data sets. But I would really like to encourage those developers to go on and not be afraid of infringing copyrights. And this is actually what limits them and what limits the innovation there. Because we are always talking about what does limit the developers. And it's the uncertainty, and I have heard this word quite a lot in this conference, about what they can do and what they can't do. And so this is why I think, obviously, we need a regulation about this, about open data sets in the EU, and the first time probably in the copyright law. So yes, this is what I wanted to present on this side. But let me add maybe and show you that also what an open model could look like and how we could achieve an open AI, yeah, I don't mean open AI, open AI model. So let me introduce our Wikidata AI project. In case you haven't heard of it, have a look at it. Or Wikidata, it's also a project. Yeah, there are different projects. So the Wikidata project converts roughly 120 million Wikidata items into multi-language vectors. It's like really techy, yeah. So I'm trying to explain what I can explain about this, because obviously I'm not a techie. So it's super great. Like, try to play around with Wikidata maybe. But the great thing about this is actually a project where you only get verified data. So no hallucination. Great, right? So it is possible to create those kind of things. So I would absolutely encourage to make more open AI models possible, especially in Europe. And thank you for your attention. And I'm now really happy to discuss further.
Thank you very much. Well, you may ask what I'm doing here. I kind of, gently disagree with these guys, but I know that everyone here is, full of questions. So as we are slightly late and we only have 20 minutes, I will hold my questions for a moment, open to the public to see if any of you would like to make any question, regarding the study, Wikimedia, the social side as pointed by Mariana. Anyone? No? So okay, I will start with mine then. If no one? Are sure? Okay, I'll start with mine then. So they study, and most of in some studies, basically stated that foundation models do not retain individual works and instead learn from abstracted statistical representations, as it was well shown by Professor Juliano. However, there are computer science papers that I will not enter in or discuss here. They do not discuss copyright itself, but by empirical investigation about the model behavior, they show that these models can memorize and that the training examples may be extracted for them. Given these findings, that's kind of contradictory to the studies provided and the opinions provided. How should the study's conclusions be interpreted, and how should the opinion of the three of you be understood? Does the possibility of extractable memorization challenge the premise that models do not retain individual works, or would you consider these cases merely exceptional phenomena rather than evidence against the broader argument? Additionally, if memorized material can be extracted from a model, what threshold would be sufficient for that memorization to become legally relevant? It wouldn't be a copyright infringement. So it's open for the three of you.
Okay, maybe I may start. Actually, the term memorization is under brackets. I prefer the term regurgitation, because actually memorization gives the impression that some of the data related to specific works are somehow stored. But that's not what happened. Actually, all the data that is used on the training phase for foundational models, they could be discarded. Usually, when it's kept, it's for future training. So there is no such a thing as storing or memorizing in this sense. It's a statistical phenomenon, as I said, when you have too many variables. So when you fill in the request or in the prompt a great part of the elements that would individualize some part or some aspects of a particular work, it's possible that with a high degree of probability, it would guess something similar to what was in databases. But I think that the important question is that there are techniques on these papers that you mentioned. You developed some techniques to try to make the system regurgitate a particular work. So it's something about the inference phase. The relevant question, I think was put forward by Mariana, whether we can, of course, analytically, we can separate training and then the inference phase. And we can do it legally to try to provide legal answers only for the training phase, disconsidering the inference phase. The question is, should we do that? It's a good question made by Mariana. Shouldn't we have an holistic view of it? And I think that in some sense the German decision did it. The German decision was interpreting the TDM exception. And actually, although there was evidence, and I believe they agreed that there was evidence that there was no storage of these particular data, the fact that you may reproduce in the inference phase, even in a malicious use, they interpreted this as saying that once you can reproduce it later in the inference phase by particular prompts or techniques, you cannot say that there is a temporary manipulation of these databases, that somehow it survives. Yeah, but actually, I was talking with you a little bit before. Actually, this is okay. You can do equiparations in the legal reasoning. It's usual to do that, but actually, you are going to equiparate aspects that may be provided by different actors, and that's why I believe this is dangerous. Because the actors that are responsible for the training phase are not the same. Of course, they provide a technology that enable them. But saying that there is a link between these two different periods that breaks the idea of something temporary, I think it's dangerous because there are different agents involved. And I think that the main problem with that we are just debating, for instance, in Brazil, but also in other countries that are considering legislation about Gen AI, is actually the development of the technology in the country. And then you should consider only the training phase. And there are voices also in the public debate, as Mariana knows, in Brazil, where they defend that actually there is this right, there is a fundamental right of author to be claimed in this case. So there will be no discussion at all. So that's why I'm defending the quite opposite position, that there is actually no reproduction at all. And even I believe we could contend the German decision by saying you don't even have to use the TDM exception and discuss the case in their terms, because it's not actually an act of reproduction, at least the training procedure.
Just a quick reference, the German case, the GIMA case versus OpenAI, that was judged by the Munich court, and also one of the only cases that discuss moral rights. Unfortunately, is not one of the topics, but it's quite interesting. Yeah. So, Mariana, Saskia, would you like to complement?
The German case, because there are many cases.
It's okay.
That's okay, just to clarify.
No, what I just want to add, I mean, it's like reading a book, right? You read it, like the AI training itself. You read it, and then so that what's happening in your mind can't be, that's what you explained, right? Mm-hmm. It's not a reproduction. So I would totally agree that on the point of AI training itself, that you can't really summarize it at the end as a reproduction. And I mean, as I said, it probably also depends on what the prompt maybe then is about, but this is like after the training process itself. So in the German case, I mean, let's see, it will go obviously to appeal, and let's see how they will decide there. But it's rather interesting on how they will decide. But I don't want to do any predictions here. But yeah, I could imagine that they maybe stick to the decision, but let's see.
I really like your remark on the concern about keeping the content free that was licensed under free regime, and the contribution of Wikipedia, which is actually very important research for AI training, at least for large language models. It's interesting because it's difficult. We know also, for giving some points to Mariana's position, that in this case particularly, there will be many inference procedures where you will capture, even especially if you prompt by using Wikipedia, and then you can produce produce outputs out of that content by many authors that are going to be appropriated. I don't know, it's not going to be any more licensed under the free license. I haven't thought about it. It's an argument to see that we should look it more holistically, I think.
Yeah, I mean, and I also meant like if they rely on the AI training itself also on free open data, right? Then I would actually expect, that they have a look at the licenses and just maybe then it's more, of course, if you apply the TDM, more a thing of fairness to at least pay attribution and maybe think about what share alike means. So yeah, I think Mariana said that, of course, that could also lead to a different direction of maybe more closed data, and licensing and everything. But I would really strongly argue that we really need to make it possible that the attribution is shared from the big companies who train their models on free knowledge.
Yeah.
Well,
I can
sorry.
perhaps jump in, So on the part of whether there is some kind of memorization at the training phase or not, I really don't feel competent to agree or disagree. I think what I'd like to address in this question is that there is, right, an underlying question of political economy, I feel. And I feel that the copyright systems, especially in the continental world, right, they're not really equipped to deal with this. We're really discussing this at the level of concepts. Is this a reproduction? Is this not a reproduction? Does this violate this and this and that right of copyright holders, right? Which is somewhat different in the Anglo-Saxon system, where, for example, when you're analyzing fair use, you really analyze economic issues, right? And fundamental issues on substitution and the interests of the different parties and the balance that needs to be achieved. And this is not structurally part of how we interpret copyright in continental law, right? At the same time, I think it's very much part of how parties argue, right, for different sides of things. So Juliano was mentioning that there's a very strong reasoning, even using constitutional law in Brazil, to say that authors have a right to consent or not to having their works used by training, whereas you can have a completely different argumentation, right, that this is not a relevant act for copyright because it doesn't involve expressive uses of the work. So what I find really interesting is to look at these normative questions, right? So should we be thinking of schemes for remuneration, and where and by whom, right? Because I think these are the questions that might lead even to copyright reform more than just interpreting, right, the current law. And I think what we're all referring to is a current situation in which these models are trained with huge amounts of data, and that has been done with almost no control, right? Referring to data protection, referring to copyright, opt-outs, which were already present in the European legislation, of the terms of the licenses. Right, so the terms of the licenses in open licensing, they're not being observed at all. Information is just used without even looking at this, right? So one could have a normative argument that this is good and that it's not at this level that these controls should be done, but one could also have a normative argument that this is producing imbalances, right? And I think part of the normative argument on that it's good, it's also basing on these ideas of scaling laws, which are also under question as well right now, right? So I also think that it's important to demystify these things. Like, what would be an AI training that wouldn't depend on just scraping the whole internet with no control, right? Is that even possible? Is that possible? How would it look like? And I think these are important questions.
Thank you, Mariana. Thank you, Saskia, Juliano. Anyone has any question? No. The problem is we have more 5 minutes. I have a page full of questions that you can see, and I'm thinking that all of you are slightly tired. So just to kind of quickly wrap up what we have discussed, as mostly we're trying to respond how, should be the future of copyright and generative AI, mostly to training. If this is an infringement or not during the training, if there is memorization or not, how should be the remuneration in this regard. So I would like to ask the speakers to give a final thoughts or final conclusions of their phases. And if there's any time, maybe in the future, I will start asking about collective management, constitutional law, include some questions about the future of remuneration or practitioner. But I believe, by Saskia left, I believe that we do not have time for it, unfortunately. But
I think we probably could spend a whole conference about copyright and AI topics, and not only talking about copyright, personality rights. I was just thinking about it when you showed the picture, right? It's also a huge topic, especially in the EU at the moment, about deepfakes, etc. We probably could.
And Brazil is a reference for it. It's the only country who has a proposition included in the bill, talking about it.
See,
I
yeah,
say
so
that's the ideal, but
as I said, you probably could hold a whole conference, which would be really interesting.
Yeah, which is an argument not to do it, because if you are the only one, the models are going to be training elsewhere.
Sure.
I'm pro-author, sorry. I will also think about collective management. I will discuss about what UK is doing, so everything. So I'll be quiet right now. I promise I'll control myself and let you guys give the final speech and final conclusions. Please, Professor Juliano.
Yeah, okay, well, I agree with Mariana to the fact that the Anglo-Saxon tradition is more flexible, because in this tradition, the societal component that I have mentioned is stronger. It's more about what is the social implications, how the value is produced in society by these cultural works. So there are many cases under discussion in US. There is this recent one in UK, which is quite thoroughly developed about the training phase. And I believe they have more flexibility. In the continental tradition, the emphasis is on the individual component of the individual right. So it's more difficult. But even though I believe that it's important to go on the foundations of copyright, because the very notion of copyright, which is based on many analogies with the physical realm, is being definitely challenged. And maybe the tissue of the legal concepts surrounding any structure of copyright are under limit. So new concepts must come, new forms of remuneration that are not based on copyright indemnization must be thought of. Otherwise, it would be impossible to sustain the concept of copyright as it was designed. It all started with Wikipedia, this challenge, and now it's becoming harder and harder.
So I can just repeat myself, actually, as my last word. So, let's just stand up for real open AI models, where we can just keep free knowledge free. And so, yes, and of course, have a look at Wikipedia again and may edit something. That we can share the free knowledge.
Thank you all for this exciting discussion. I think my last words would be on something that we didn't properly address. We're really speaking of commercial training, right? But I find it super important that also training for public interest purposes is also discussed, is also part of the discussion, right? I think this is a distinction that the EU Copyright Directive does and does very well, trying to exempting, right, educational institutions, museums, libraries, archives, from even obtaining authorization, right, for using works for training. And I find that this is a very important aspect in this balance that we're speaking of the world we want, and of an open AI and of open knowledge and all of those things. So I didn't want to let this panel finish without bringing this up as well, that I think making this differentiation is really essential.
Thank you, everyone, for being here. I think that the final recommendation that I would say is that we should probably, for this discussion, have more people discussing, like more the society, more experts discussing, and more participation on what should be done. I'm not recommending to do just like the UK, because they just step back with the white paper, they keep changing their opinion, but maybe, the participation of you guys in this would be fantastic. The opinions of Mariana, Valente, Saskia, Juliano, all different opinions, trying to bring it together to what we are going to do. Because copyright will change it and develop for every time, for every new development. So what is the future that we would like to bring? It's more open. Knowledge should be open. Should we pay for the training or not? What should we do? That's my final thought. So thank you, everyone. That's it.